We take a report from Institute of Intellectual Property by October 2021. Welcome again to the K discussion, and today we will discuss the K concerned to the Folsom and Marsh. That's very landmark case of the U.S. in 1841 of the Circuit Court of Massachusetts between Folsom versus Marsh. Bill in equity for privacy of copyright of the writing of Washington. The bill in substance stated that Judge Spad were the authors of a work entitled The Writing of George Washington, being his correspondence, addresses, messages, and other paper, official and private, selected and published from original manuscript with a life of author, note, and illustration by Spark consisting of 12 volumes, of all of which the copyright were duly taken out. The term of which copyright has still more than 8 years to run. That the plaintiff Charles Folsom, Thomas Well, Lyman Thurston, printer and publisher, under the style of Folsom, Well and Thurston, had assumed a part of risk and responsibility of publishing a said work, and being in receipt of large sum, the proceeds of the sale of the said work, Marsh, Nachum, Carpen, Thomas, and Garden bookseller, under the firm of Marsh, Carpen and Lyon, and Charles Upham, as well know that said Spot held such copy, and that the said Folsom, Well, and Thurston were interested as aforesaid, and deliberating after due notice, intending to infringe upon the said copyright at Boston on August 5th, 1840, and at the driver time before sin without the allowance or consent of the orator, or either of them published and exposed to say and sound a book in 2 volumes entitled Life of Washington in form of an autobiography and narrative being to great extent conducted by himself. In extract and selection from his own writing, his portrait and other engraving consisting of 866 pages, which they still continue to expose to say, having had due notice and well knowing that the same is copied from and on infringement and privacy of the satellite and writing of Washington, so published by the plaintiff. The 388 pages of the said piratical books are copied verbatim and literatim from the said work, compiled by the said Spark, consisting of matter published of original by said Spark under his copyright, and his has never before been published and printed, and with the said Spark has the exclusive right and privilege to print, publish, and sell, and that many other parts of the piratical work are infringement of the said Spark, said copyright, whereby the plaintiff had sustained great damage, and that the said Smart Carbon Alliance still threatened to continue to print, publish, and sell copy of the said piratical work. In consideration thereof, the plaintiff prayed that the defendant has agreed to render on account of a copy of the said piratical work, which they have sold, and to pay over the profit thereof to the plaintiff, to surrender and deliver up all the copy on hand and the stereotype plat of the said work to an officer of a court, to be cancelled and destroyed, to pay the plaintiff their cost, and that they be restrained by injunction from selling or exposing to say, or causing to be exposed to say so, and otherwise disposing any copy of the said piracy work, and for such other relief as so seem meet or as equally so required. The answer stated as follows: that the defendant not confessing or acknowledging any the matter and things alleged in the bill are informed and believe that the said complainant are the publisher of the said Life of Writing of Washington, and alleged by the complainant, and that the said spot is author thereof. But that nature totally deny that the said spot has or had heretofore had any copyright where he entitled to any exclusive publication of said writing, correspondence, addresses, messages, and other paper. That dependent did on August 5th, 1840. Public and sale, and before he should have without the allowance and consent of plaintiff, published a sole copy of the said work in two volumes entitled July Washington in the form of autobiography, but the said work is not in a copy form, nor a piracy or said work by said Spock. The defendant denied that any part of the said work published by defendants is copied verbatim and literally from any portion of said work by the said Spock, to which he has any exclusive right and privileges to print or publish or sell, but they averred that they have in work published by them, message you and they might lawfully do of the writing, correspondence, messages, addresses, and all the paper by George Washington. Printed in work compiled by the said Spock, and that they had compiled many pages of the said writing from the original manuscript thereof and from printed work, printed and published before the publication of said work by the said Spock, and they have made such use thereof as they might do in a work entirely distinct from independent of the said work by the said Spock, and they allege that the said work published by them is entirely a distinct and independent work from the work said by Spock. The general replication being filed, the cause referred to George Hitler, Master of Chancery, to ascertain report the fact through the court. He report in substance state as follows. The work of which plaintiff are the favorite is comprised of 12 octavo volumes, varying the length from 540 to 592 pages, and containing in the whole 6,763 pages, including 158 pages of index in 12 volumes. The first volume consists of an original line of Washington by Mr. Spock, one of plaintiff, and remaining 11 of the writing correspondent Washington, with editorial notes and illustration by Mr. Spock. The work, of which the defendant are the proprietor, is in two volumes dus simo. The first volume consists of 443 pages, including 40 pages of glossary and index. The second volume consists of 423 pages, including 35 pages of glossary and index. The whole amount of the pages of two volumes is therefore 866, including 76 pages of glossary and index. I find the whole number of pages in the two volumes of defendant work, which correspond with the pages of plaintiff work, and are identical with them, to be discarding fraction. 353 of these pages, 390 have been never appeared print before the publication of plaintiff work, and I accordingly report them to have been copied by defendant from the work of the plaintiff. The remaining 34 pages have appeared before in various other publications, with the variation herein before stated. In view of this variation, and also in consideration of fact that these pages independent work, generally speaking, differ in punctuation and other typographical peculiarity from the same passages and containing work other than that of plaintiff. I find that these 30 pages were taken by defendant from plaintiff work and not others. The whole of these 353 pages in two volumes of defendant work are taken from the last 11 volume of work of the plaintiff. Of the 319 pages, Above mentioned which are the work of the defendant and which have not been published in any other work than that of the plaintiff. I report 64 pages should be official letter and document, and 250 pages should be private. Of the remaining 34 pages, I report 15 pages should be private, and 19 pages should be unofficial. Under the head of official letter and papers, I class the following: letter addressed by Washington and Commander-in-Chief to the President Congress, official letter to Governor, to State Speaker of Legislative Body, circular letter, general order, communication official addressed by President to his cabinet, letter accepting the command of army and our respective war with funds, and order class as private. The courts argue upon matter reports, no exception having implied thereto by Mr. Robin and Weiler Caleb for the plaintiff by the Ranter for the defendants. The point made by the defendant are followed. First one, the paper of George Washington are not subject to copyright. Their manuscript of deceased person not insured by publication of them. Second, they are not literary and therefore are not literary property. Third one, they are published in their nature and therefore are not private property. Four, they were meant by the author to publish use. Mr. Spot is not the owner of this paper, but they belong to United States and may be published by anyone. An author has the right to quote, select, extract, or abridge from another in a composition of work essentially new, story justice. It's one of those intricate and embarrassing questions arising in administration and civil justice, in which is it not, from peculiar nature and character of controversy, easy and arrive at any satisfaction conclusion, or laid out as a general principle applicable to all cases, patent and copyright approach nearer than any other class of cases belong to the forensic discussion to what may be called the metaphysics of the law, where distinction are, or at least maybe, very subtle and refined, and sometimes almost evanescent in many cases. Indeed, what constitutes an infringement of patented invention is sufficiently clear and obvious, and stand upon broad and general agreement and differences. But in other cases, the line approach very near to each other, and sometimes become almost evanescent or melt into each other. So in case of copyright, it is open exceedingly obvious that the whole substance of one book has been copied from another, which lie omission and formal differences only, which can be treated in no other way than study evasion. Whereas in other cases, the identity of two work in substance and the question of privacy are depend upon a nice balance of a comparative use making one of the material of the orders and nature, extent, value, and material thus use, the object of each work, and the degree to which each writer may be fairly presumed to have resorted to the same common sources of information, or to have exercised the same common diligence of the selection and arrangement of the material. Thus, for example, no one can doubt that a reviewer may fairly cite largely from original work if his design can be really truly to use the passage for the purpose of fair and reasonable criticism. On the other hand, it is clear that he thus cites the most important part of the work with a view not to criticize but to supersede the use of the original work and substitute the review for it. Such a use will be deemed in law of privacy. A wide interval might, of course, exist between these two extremes, call for greater caution of involving great difficulty where the court is approaching the dividing middle lines which separate the one from another. So it has been decided that a fair and bona fide abridgment of original work is not a privacy of copyright of the author, but then what constitutes a fair bona fide abridgment in the sense of law is one of the most difficult born under particular circumstances. It can be well arise for judicial discussion. It is clear that a mere selection or different arrangement on part of the original work so as to bring the work into smaller encompass will not be held to be such an abridgment. There must be real substantial condemnation of material and intellectual labor and judgment bestowed thereon, and not merely the facile use of the seizure or extract from essential part constituting the chief value of the original work. In the present case, the work alleged to be pirated is the writing of President Washington in 12 volume Royal October, containing nearly 7,000 pages, of which the first volume contained Live Washington by the learned editor Mr. Scott, in respect to which no piracy is accepted or proved. The other 11 volume consists of a letter of Washington, private and official, and his message and other public act, with explanatory note and occasional illustration by editor. That the original work is of very great, and may almost say of inestimable value, as the repository of the thoughts and opinion that great men no one pretend to doubt. The work of the defendant on his 6th volume, Du Sedimo, contains 866 pages. It consists of Live Washington, written by learned defendant Charles Upham, which is formed upon a plan different from Mr. Spot, and in which Washington makes mainly to tell story of his own life by asserting in his letter and his messages, and other written document, which is connecting line in the narrative, and as may illustrate, explain the time and circumstances and occasion of writing them. Now, as I have already said, there is no complaint that Mr. Upham has taken his narrative out substantively from line of Mr. Spot. The argument is that he has used a letter of Washington and insert verbatim copy thereof from collection of Mr. Spot, masterfied by his report and a whole number of paper Mr. Upham work corresponding and identical with the passage of Mr. Spot's work are 353 pages out of 866, a fraction more than 1/3 of 2 volumes of the defendant. Of these 353 pages, the report finds that 390 pages consist of letter Washington, which have been taken from Mr. Sparks' work and have never been published before, namely 64 pages of official letter and all document and 255 pages of private letter of Washington. The question, therefore, upon this admittment, state of the fact resolve itself into the point whether such use in the defendant work of letter Washington constitute a piracy of the work of Mr. Sparks. It is objective, in the first place, on behalf of the defendants, that the letter of Washington are not, in the sense of law, proper subject to copyright for several reasons. And here are several reasons. First, because they are the manuscript of decent person not injured by publication thereof. Second, because they are not literary composition and thereof not susceptible of being literary property and not esteemed by value by the author. Third, because they are in their nature and character, either published or official letter or private letter or business. And lastly, because they were designed by the author for public use and not infringed copyright of private property. Now, in relation to the last objection, which is more manifest that President Washington deemed them his own privacy property and beneath them to his nephew and later Mr. Justice Washington, through whom the latter Mr. Chief Justice Marshall and Mr. Spot acquired an interest therein, and as appeared from a contract between these gentlemen. And as to the report, the publication of this writing was undertaken by Mr. Spot as editor for their joint benefit, and the work itself had been accomplished as great expense and labor, and after great intellectual effort and very patient and comprehensive research, both at home and abroad. The publication defendant therefore to some extent must be injurious to the right of property of their representative, the Chinese President Washington. Indeed said well, we shall presently see Congress had actually purchased this very letter and manuscript at a great price for the benefit of nation from their owner and possessor under the will of Mr. Justice Washington, a private and most valuable property. The President Washington therefore intended them exclusively to publish you as a donation to the public and did not esteem them a value as his own private property. Appear to me to be a proposition completely disproved by the evidence. Unless indeed there be a most unequivocal dedication of private letter and paper by the author, either to the public or to some private person. I hold that the author had the property therein. And that the copyright therefore exclusively belongs to him. Then as the supposed distinction between a letter of business or mere private domestic character and letter, which from their character and content are to be treated as literary composition, I'm not prepared to admit its soundness and probity. It's extremely difficult to say what letter are and are not literary composition. In one sense, all letters are literary, for they consist of the thought, a language, a letter, reduced to written character. And so his style and his mode of constructing sentences and his habit of composition. Many letter business also embrace critical remark and expression of opinion of various subjects, moral, religious, political, literary, what is to be done in such cases. Even composition confessedly, literally the author may not intend, nay, often does not intend them for publication, and yet no one that account out his right of property gains at a subject of value himself and to his posterity. If subsequent published by his representative, would they not have a copyright gain? Is it highly probable that neither law Chesterfield nor law offered nor portray even intended the latter for publication as literary composition, although they are about with striking remark and elegant sketches, and sometimes with the most profound, as well as affecting exhibition of glow reflection. And whereas knowledge and experience meets up with master of business, personal anecdote, and family gossip. There is no more small confusion in the book. In reference to the question of copyright in letter, some of the dictators seem to suppose that no copyright can exist except in letter which are professedly literary, while others again recognize much more in laws by liberal doctrine. Without attempting to reconcile or even to comment upon the language of authority of his hand, I will state that I conceive to be the true doctrine upon the whole subject. In the first place, I hold that the author of any letter or letter and his representative, whether they are literary composition or familiar letter or letter of business, possess the sole and exclusive copy therein, and that no person, neither those to whom they are addressed, nor all the person have any right of authority to publish the same upon their own account for their own benefit. But consistently with this right, the person to whom they are addressed may have named or implication possess the right to publish any letter addressed to them. Upon such occasion I require justify the publication or public use of them. But this right is strictly limited to such occasion. Thus a person may justifiable use and publish in suit of law in equity, such letter or letter as are necessary and proper to establish his right to maintain the suit or defend the same. So if he be an expert or misrepresented by the writer or accused by improper conduct in the public manner, he may publish such part of such letter, but no more, and may be necessary to vindicate his character and reputation, free him from unjust, unlawful, and reproach. If it attempts to publish a letter or letter on other occasion, not justifiable, a court of equity will prevent the publication by an injunction as a breach of private confidence of contract or the right of the author and a forgery. If they attempt to publish them for profit, for then it's not a mere breach of confidence of contracts, but it is violation of exclusive copyright of the writer. In short, the person to whom letter are addressed had but a limited right of special property, if I may so call it, in such letter at trustee or barely for particular purposes. Either of the information of protection or of support his own right character, the general right incident to property belong to the right, whether letter a literary composition or family letter, or the tenor fact letter business. The general property of manuscript remain in writer and his representative, as well as the general copyright. A fortiori, thus person standing in no privity with either party are not entitled to publish them, to subserve their own private purposes of interest or curiosity or passion. Indeed, if the doctrine were otherwise, that no person of his representative could have a copyright in his own private and familiar letter. Writer to friends upon interesting political or education or containing detailed fact of current passing before the writer. It could operate as a greater discourage upon the collected and preservation thereof, and the material of history would become far more scanty than it otherwise would be. So, and then the just mentioned about doctrine, the distinction, question. This quite very long for this opinion. So he come to some conclusion. I have to come to this conclusion, not without some regret. This may interfere in some measure with the very meritorious labor of the defendant in the great undertaking of series of work adapted to school library by just entitled in this case as in order only to know and to act upon his duty. I hope, however, that some means may be found to produce an amicable settlement of this unhappy controversy. The reports of master must stand confirmed and a perpetual injunction be awarded, restraining the defendant, the agent, servant, and salesman from further printing, publishing, selling, or disposition any copy of work collected in Live Washington by Rip Charles Upham contain any 390 letter Washington State report on master and never before published. And that is be referred to the master to take account of profit may be defendant in the premises would leave for 80 party to apply the court for further direction. So that's the opinion of William Story. So you can see the case law very interesting and not really to not easy to understand the case law as always. So in order to be more easy to understand, we will see again a summary of the case. What about rules? A fair and bona fide abridgment of original work is not a piracy of the copyright of the author. But then what constitutes a fair and bona fide abridgment in the sense of law is one of the most difficult points that can well arise for judicial discussion. It is clear that a mere selection or different arrangement of part of the original work so as to bring the work into a smaller compass will not be held to be such an abridgment. There must be real, substantial condemnation of the material and intellectual labor and judgment bestowed thereon, and not merely the fussy use of the seizure or extract of the sense of part constitution the chief value of the original work. What about the fact? Plaintiff alleged that defendant invalid copyright by publishing verbatim copy of the letter of former President George Washington. A little over 1/3 of defendant publications were interspersed with never before published official letter, document, and private letter by Washington. The rest of publication consisted of a native Washington line with explanatory noted and illustration by the editor. What is the issue? Did the defendant verbatim use in his own publication of letter of former President Washington constitute an act of piracy that violates plaintiff copyright in the original work that a letter has been taken from? The answer is yes. Conclusion. The circuit court held that plaintiff copyright has been violated, pirated, because the defendant publication were not a fair bona fide infringement of an original work. There were no real substantial condemnation on the material thus constituting a true labor of intellect. If the defendant would take 390 letters, include the plaintiff copyright exclusive belong to them, there were no reason why another bookseller could not do the same. So that's the case. Very well. So if you have any other question, please contact to us and can discuss more about the case. We take a report from Institute of Intellectual Property Implementation, 5 October 2021. Thank you and see you in the next presentation.